This is News 24. I'm Erin Bates. One story that's dominated news since last week is the information that South Africa has given notice it's planning to withdraw from states or nations that are listed as signatories in the Rome Statute, and that we're basically leaving the ICC, the International Criminal Court. Now, with me today is Lawson Naidoo from the Council for the Advancement of the South African Constitution. And Lawson, you're going to help us understand the kind of legalities of this decision and what case there may be for contending it.
Indeed, and I'm pleased to announce, Erin, that this morning CASAC has lodged an application in the Constitutional Court to challenge this decision by government to put forward the instrument of withdrawal to the United Nations last week. We believe that there is no basis in law for government to have done that. It's a fundamental breach of the separation of powers, in that the Constitution clearly gives a responsibility to Parliament to take decisions regarding the binding effect of international treaties, and therefore it is Parliament that needs to be charged with any decision to extricate ourselves from those responsibilities, and the executive have no role to play in initiating that process.
That's astounding news. I mean, this is a breaking story then, that you as an institution of civil society have decided to contest what the Minister of International Relations and Cooperation has written and signed off.
Yeah, because it is our firm belief that there is absolutely no basis in law for the Minister to have taken that decision, or indeed for the President to have taken that decision. This is a matter that resides with Parliament, who ratified the Rome Statute and also passed a piece of legislation domesticating our responsibilities in relation to the international treaty into our domestic law. So for the executive to take action without Parliament even having discussed the matter is highly irregular.
So that's something that the Minister of Justice dealt with when he had his briefing on Friday, and Michael Masuta, the minister, said that he would be referring elements of the decision to Parliament. It sounds like what you're saying is that the whole decision, the wholesale decision, needs to be debated, and I suppose then in the Constitutional Court.
Indeed. In fact, what the Minister has done is, in fact, to put the proverbial cart before the horse. This is a matter that should have started in Parliament. Parliament should have taken a decision as to whether it wants to review South Africa's membership of the International Criminal Court and its status within the Rome Statute before any action is taken by the executive. The fact that Parliament has not done so means that this decision by government can have no legal effect whatsoever, and we are calling on the court to compel the government to withdraw its intention to withdraw.
So who are the respondents then in your case?
Well, it's the President, it's the Minister of Justice, it's the Minister for International Cooperation, it's the presiding officers of Parliament, the National Prosecuting Authority. Those are the primary respondents in our matter.
You've got quite a pile of papers in front of you.
We have. These papers were literally served this morning, and I've just received them from our legal team in Johannesburg. And these papers, as I said, were filed in the court this morning. We're asking that the matter be heard by the Constitutional Court on an urgent basis, because the clock is already ticking if we do not challenge this decision, because government has given notification in terms of the 12-month withdrawal period.
Yes.
So we want this matter dealt with urgently. The appeal by the government in relation to the Salk case, the al-Bashir matter,
yes,
is set down for hearing by the Constitutional Court on the 22nd of November. And we are asking the court to join this matter to that, so that both issues, because so many of the legal issues overlap, be dealt with and heard on the same date.
All right, so will it then be heard by the same bench?
It will be heard by the Constitutional Court if they grant us direct access. We've approached the Constitutional Court on two bases. One of direct access to the Constitutional Court, and secondly on the basis that the Constitutional Court has exclusive jurisdiction over this matter as it relates to the execution of a constitutional responsibility.
My goodness. So if you're just joining us, we're live here with Lawson Naidoo from CASAC, and we're discussing the matter of South Africa's notice to withdraw from the ICC. And we've just heard this morning breaking news that CASAC has lodged an appeal at the Constitutional Court to have that decision debated and overturned, I suppose, is what you're ultimately after?
Absolutely, yes. And it's interesting, Erin, to note that we're not the only country going through something like this. In the UK, there's a High Court case currently at the moment relating to the Brexit.
Yes.
As to whether the executive can withdraw from the European Union without parliamentary ratification of the referendum decision. Very much the same principle of the separation of powers, where the argument there is that the House of Commons needs to take a decision before the UK can invoke the provisions of Article 50 to trigger the withdrawal of Britain from Europe. And the legal principle is exactly the same in this case, is that Parliament is the appropriate body to take that decision and not government.
So in layman's terms, what you're arguing should have happened is that if the Minister of International Relations and Cooperation wished to have this concluded amongst Parliament, or it wished to kind of forward this decision, she should have taken the matter to Parliament. It should have been debated by the executive, and then once a decision had been voted upon, then sign the letter of notice.
Absolutely. That would have been the proper sequence of events, which would have given proper authority to the executive to then implement a decision of Parliament. As I say, this has got it the wrong way around.
So in that case, if we have majority ANC executive, how much leeway do you have here legally in terms of the case in the Constitutional Court?
Well, Parliament is an autonomous body, and Parliament must be given the opportunity to consider and take a considered decision on the repeal of the implementation statute, as well as the withdrawal from the Rome Statute itself. And it has not been given that opportunity, and we would certainly urge members of Parliament not to vote for the revocation of this a commitment to the Rome Statute. It has huge implications for our international standing as defenders of human rights. Yes. We have a proud history as defenders of human rights. As a country that has come out of apartheid, which was itself a crime against humanity, we are now undermining all of those issues, and our standing in the international community will be damaged by this.
Yeah, I mean, that's really the rub, though, is that a lot of critics of the ICC argue that it's very biased towards the leaders of developing countries. And so if you look at a map of the cases that have been heard to date, they are predominantly African cases. And there comes the argument that this is a European body, or it's a body that's swayed by the values of a European kind of system of ethics, and maybe American, and that it really doesn't favor developing African countries.
Well, I think that's a bit of a misnomer, and it's a convenient argument that's used without any basis in fact. There are 168 members of the Rome Statute, 34 of which are from Africa, the highest percentage from any other parts of the world. The highest percentage of countries that commit to the Rome Statute are in Africa.
That's interesting.
There are 8 of the 9 cases that have gone before the ICC have been African cases. That is absolutely true. But let's draw down a little bit below that. 4 of those cases were actually referred to the ICC by the countries themselves. 2 of those cases were referred by the United Nations Security Council, in which all of the African members of the Security Council at that time voted in favor of the referral. In fact, South Africa was a member of the Security Council at the time the Libya matter was referred to the ICC, and we supported that referral. There are only 2 cases where the ICC prosecutor has initiated an investigation on itself. So this argument that the ICC is inherently biased against African countries has no basis in fact.
Although I suppose, it would be quite nice to see some other very pertinent cases of human rights violations beyond the continent being heard too.
Absolutely, and I think it's fundamental, and what we need to be doing, and what the responsible thing to do, would be to grow the stature of the International Criminal Court, and to try and get more and more countries to sign up to it and to be bound by its provisions, rather than to walk away, especially as we're walking away with no other mechanism in place. So we're giving impunity to those that fundamentally undermine human rights, gross violations of human rights, torture, and crimes against humanity.
Yeah. Interesting, I saw that the head of the ICC, who's Senegalese, is holding a press conference in Dakar at 3 this afternoon, and he's going to address this call by Sudanese President Omar al-Bashir for other African states to join this trend set by South Africa, which you are about to try and scupper by going to the Constitutional Court. Just on that though, I mean, interesting to hear a spokesperson for the presidency in Sudan saying that the ICC targets African countries and it never targets European states, also mentioning Israel there. I know that Georgia, a matter of human rights violations in Georgia has been heard, and there have been investigations into what happened in Afghanistan with American troops there. So nothing yet in the court itself, but if you do dig a little bit deeper, there are other cases that are at least tentatively kind of looked into.
Yeah, the Georgia case was referred to the ICC earlier this year. There are other investigations ongoing, and I think it's important to say that the ICC is not a perfect body, but it's the best body that we have at the moment to deal with these gross violations of human rights, with issues of war crimes and genocide. And we need to build on the capacity of the ICC to have a greater presence across the globe and to deal with these abuses when they occur, wherever they occur. And we accept the weakness of the ICC, but South Africa's withdrawal from the ICC will do nothing to turn the tide against the abuse of human rights. And I think that's really the point that we need to be. We need to be demonstrating our support for the victims of human rights abuses and not for the perpetrators. And our withdrawal from the Rome Statute gives succor to the perpetrators of genocide.
Yeah. If we go back to last year in the African Union Summit, which is where this all really first came to a head with Omar al-Bashir here on a visit for that summit in Sandton. And I remember quite vividly being on a panel about gross sexual assaults and rapes that occurred in places like Darfur as a weapon of war, a weapon of kind of, warfare. And astounding that in the same hall hours later was al-Bashir and leaders of his ilk who some people would argue very strongly advocated for that sort of behavior and tactic as a weapon of war. Now, Michael Masuta, our Minister of Justice, said that one of the difficulties we face as long as we're still a signatory on the Rome Statute is it impairs and retards our ability to negotiate with African leaders and try and reach peaceful settlements, and that basically we become a tool of regime change. Because if we extradite Omar al-Bashir while he's here at the AU summit, then there's a vacuum back in Sudan, and then who becomes the leader? What do you make of his argument on that front?
Well, I think it's a very self-serving, weak argument. I mean, the issue is that membership of the ICC and signatory of the Rome Statute does not prevent us from playing a role as a peace broker in any of these conflicts, which South Africa has played an incredible role in South Sudan and in the Darfur region as a mediator. And that has been, whilst we have been part of the ICC. So I don't see how that really makes any sense. Yes, we must continue to play that role. We have a responsibility to do that through multilateral organizations, through SADC, the AU, and so on, to play those roles. But we also have a responsibility on humanity as in general to ensure that those who are perpetrators of gross violations of human rights are brought to book, and that there is accountability for those actions and not impunity.
I was looking through some of the details of the Rome Statute, and I mean, this is where your legal expertise is incredibly valuable, because there is a whole series of laws and documents that sort of underline and sort of provide the foundation for what the ICC does.
And the point that you made just now, Erin, about the conference you attended last year where the issue of rape as a war crime was discussed, that's an aspect of jurisprudence that the ICC has developed, of identifying systemic rape as a mechanism of a war crime. And that's something that has really helped in the fight against abuses of human rights against women and young children in particular in war situations. And those are the benefits of the ICC that people ignore at their peril.
And I mean, sexual assault and sexual violence is not isolated to women and children during war. That absolutely is, fact.
Indeed.
And I mean, I think what's going to be interesting is we're having a guest on tomorrow who was involved with the UN in Darfur in 2003 when the conflict really kind of began to come to a head. And he has documentation that the UN was privy to on the scope of violence, genocide, wholesale, forced removal of people and destruction of villages. That is what is, put at the foot of al-Bashir and kind of brings all of these questions up to a head. I just want to touch there, Lawson, on the 4 core crimes that are listed in the Rome Statute, and perhaps you can tell us where these resonate and overlap with the values and the principles of the South African Constitution, coming from CASAC as you do. So the 4 core crimes that we signed up to hold people to account for are genocide, crimes against humanity, war crimes, and crimes of aggression. Where do those crimes, which the ICC seeks to prosecute and hold people to account for instigating or kind of encouraging, Where do those resonate with the South African Constitution?
Well, they resonate primarily from our Bill of Rights, which outlaws all these sorts of practices against human rights, but also from customary international law, from the common law of international law, if you like, which is part of international law, whether it's in a treaty or not. So we are bound by these provisions, whether or not we withdraw from the Rome Statute or not, because these form part of the basis of agreed international law. And in terms of our Constitution, as the Constitutional Court has said, we are bound by our international obligations that stem from the rights that are in our own Bill of Rights. So we are bound in any case to these issues and to take action against genocide, war crimes, and so on. What we would lose by withdrawing from the Rome Statute is being able to use the mechanisms of the International Criminal Court to prosecute those crimes.
Yes.
That's what we would lose.
But now, speaking to that, you used the idiom of the cart before the horse a little earlier, and to use an associated idiom, hasn't the horse already bolted? If you look back to last year and al-Bashir being in the country, I believe that with the ICC, you don't necessarily have to go to The Hague. So it wouldn't even necessarily have been important to extradite al-Bashir. Haven't we already failed?
Well, we have failed because we fundamentally failed to adhere to our international responsibilities as well as to our domestic responsibilities. Because let us not forget that the implementation statute of the Rome Treaty is in our domestic law in South Africa. So we flouted our international obligations and we flouted our own laws passed by our own parliament last year. And this is a matter that is still, as I said just now, before the Constitutional Court. Government is appealing the Supreme Court decision to the Constitutional Court, although I understand that Minister Masuta has indicated on Friday that government will withdraw its appeal. Yes. I'm not sure that government is able to, because my understanding is that all parties to the case would have to agree before that withdrawal can take place. So this seems to be a tactic on behalf of government to avoid another defeat in the Constitutional Court, and which would render that South African government action or inaction in failing to take action against President al-Bashir was illegal, and that government officials who were complicit in that decision should be held criminally responsible for the part they played in allowing al-Bashir to flee South Africa.
Yes. So as that court case was being heard urgently and al-Bashir was being allowed to get onto a runway and fly back to Khartoum, anybody within the state kind of administration who helped that happen would then be liable for prosecution.
Absolutely, and we would hope that the investigation into those officials is progressing and that appropriate dockets will be referred to the National Prosecuting Authority and that they will take their responsibilities seriously and prosecute those involved.
I mean, on that question of this tactic, putting this forward that we're planning to resign or that the Minister of International Relations and Cooperation has signed that, Nkwana Mashabane, would that hold a lot of sway in the Constitutional Court for us to say, as the state or the lawyers for the state, well, we're already leaving, it's 12 months, we just kind of sit out the time for now? What happens in the legal kind of argument? Well,
I think, as we said right at the very beginning, this is a fundamental principle relating to the separation of powers. And this potentially is one of the most important cases that the Constitutional Court has heard so far, because it goes to the very heart of our Constitution about who has the power to exercise responsibility in various issues. And to weaken the ability of Parliament to determine binding issues relating to fundamental human rights, to relating to South Africa's responsibilities is critical. And we think that this case is something that the court will have to consider and will have to take a decision to guide us in terms of what the powers of the legislature are vis-à-vis the powers of the executive. The Constitution says that the government can negotiate and discuss treaties, but ultimately the final decision to give binding effect to those treaties is Parliament. You will be aware that there is a two-stage process when we deal with international treaties and agreements. First is the signature of that, which is done by government. It evinces an intent to be bound by it, but it has no binding power on its own. It is only after Parliament has ratified that decision that South Africa is then bound by the provisions of that agreement. So Parliament plays a critical role in that, and that's a role that we think that the Constitutional Court needs to emphasize.
So there's a two-step process for being a signatory or being a kind of member state.
Being bound by.
Yes, being bound by. So then in order to retreat or withdraw, one has to, you argue, go two steps back. So you start in the executive, you start in Parliament. Once you have consensus there, then you can go to the point where the minister can sign the notice to withdraw.
The example of the United States is a good one. When Bill Clinton was still president, they signed the Rome Statute.
Okay.
When President Bush came into power, they decided not to ratify, and they therefore withdrew their signature. Yeah. But there was no binding effect on the US at that time.
It was just an intent.
It's unfortunate that they have chosen not to ratify. Yeah. I'm not supporting that decision at all, but I'm just demonstrating, using that as a mechanism to demonstrate how the signature and the ratification have different legal effects.
Yes. I thought it quite interesting. There was an article, I can't recall exactly which organization it was, but some US-based organization expressing concern and displeasure at the fact that South Africa had issued this notice to withdraw. And someone on Twitter, in fact, very pointedly noting that America is not a signatory. And I don't know if that's necessarily the comparison we want to make, is that, well, America didn't sign, so we shouldn't either.
We must hold ourselves to a higher standard than others. Our standards are set in our Constitution, and the issue of fundamental human rights is central to our Constitution, and we must demonstrate and live up to those standards in our international relations.
I can't help but having this conversation think about how grave, in fact, this matter is. And, you know, I think it's very important to understand and evaluate these questions around the perceived bias. And if you look at the sheer numbers of cases and who's been prosecuted and brought to book, the existing kind of, you know, track record of persecuting or prosecuting African leaders, but at the same time, if you, like you say, look at the values of our Constitution and you look at what the ICC, the Rome Statute, seeks to prosecute and seeks to bring to book, it's a very, very important and serious question.
It is. I mean, the issue of human rights is the issue of our times at a global level. And we, as South Africa, are now playing fast and loose with our responsibilities to the rest of humanity. Not just to people in South Africa, but to the rest of humanity.
And to our procedures as well. This could potentially set a precedent, is that if a minister gets a whim about signing us out of a treaty, which is meant to go through certain procedures in cabinet, then, you know, we'll be dropping them like flies.
Well, absolutely, and I think, you know, this demonstrates how the Constitution is continuously being undermined by government. We had the judgment of the Constitutional Court earlier this year in the Nkandla matter, where the President was found to have acted in violation of his constitutional responsibilities. This is likely to be another case where a similar finding is made against the Executive. And the Executive are continuously acting in a manner that undermines our Constitution. And we need to put a stop to that.
Is that out of sheer ignorance, would you wager, or is it out of impunity for the values of our Constitution?
I think it's impunity, it's a lack of accountability, and it's a lack of responsible leadership to really respect our Constitution and the demands that it places on different arms of the state in South Africa. And I think our Constitution is being undermined by these actions. And as I say, from that point of view, it is incredibly serious. And that is why CASAC took the decision to take this matter directly to the Constitutional Court, because we need an urgent clarification of the powers of the Executive vis-à-vis the legislature.
So if you've joined us a little bit late this morning during our live discussion with Lawson Naidoo, or this afternoon rather, news that CASAC has brought papers to the Constitutional Court asking for the matter of our withdrawal or intent to withdraw from the ICC to be heard by the Constitutional Court. And you said that court date is the 22nd of November.
Well, we've asked for it to be heard on that date. Obviously, we will take guidance from the court in that regard.
All right. Lawson, then just to come to this question of diplomatic immunity, how does that stand in contrast with our commitments as they are today in the Rome Statute? Does the one trump the other? Are they equally viable?
Well, the courts have already found, including the Supreme Court in the Salk matter, has found that the Rome Statute trumps the Diplomatic Immunities Convention, and that surely the rights of those that are being fundamentally undermined through gross human rights violations, through war crimes and genocide, those rights carry more weight than the rights of heads of state who may have perpetrated those crimes. And that's the fundamental moral question that we have to ask ourselves.
Yeah. So you have hundreds of thousands of people in Darfur who've been pushed off their land, raped, murdered and killed, and those rights are more important and pressing, you would argue, and the documentation, the Rome Statute itself argues, than the right of al-Bashir to attend an AU summit in Sandton for 2 days.
Absolutely.
Well, I wonder what's going to happen in the Constitutional Court. I'm hoping you're going to get that hearing on the 22nd of November. And it's going to be interesting to see what happens with the case going forward. I want to ask, Lawson, in terms of the initial visit, that visit in 2015 for the AU summit, do you think government officials, I suppose this is dangerous territory because it's speculation, but what are the chances that government officials knew that this was flouting the Rome Statute and figured we'd get away with it because of diplomatic immunity?
Well, they obviously felt that they could get away with it on some basis, and I think that's why criminal prosecutions are necessary, so that those officials who were complicit in this decision in allowing President al-Bashir to leave are held to account and can defend themselves in court and if necessary, provide the context in which they acted in the way that they did.
I think what is complicating, or certainly for me has made the whole question of al-Bashir and Darfur a little bit more nuanced and difficult to grapple with, is going through some of the information and reporting from when the ICC first issued its warrant of arrest. And he's one of 13 people, suspects at large still from the ICC. And when that happened, there were a number of demonstrations by al-Bashir supporters both in Sudan and in places like the United Kingdom, who went outside their embassy to say that he should not be tried and he should not be held accountable for what happened there. So as much as, you know, at face value to me anyway, there seems to be a very clear argument for why he should appear in court and should answer for what happened there, that there isn't the same kind of, you know, sort of blanket consensus in Sudan itself.
Well, you know, in a sense, I mean, that's exactly why an international body is so important, because it takes it elevates these conflicts outside of their localities, and you will always have these tensions within, for example, within the Sudan, where you find people on both sides of the divide on this matter, and that's why it is an international humanitarian responsibility for the international community to say these actions that have taken place violate the principles that we hold dear, and we will therefore, as the international community, take action against it.
You spoke earlier about our efforts as South Africa to be involved in peaceful negotiations, and interesting also, Nkosazana Dlamini-Zuma, chairperson of the AU, speaking in Pretoria this morning, say we need stability, we need peace on the continent, and arguing quite strongly for that. She didn't go into the details of the section I heard on the ICC in particular, or Sudan. But I mean, the question around Africa and diplomacy, is it, you know, within the kind of context of this debate and this discussion, is it more sort of fair or kind of tolerable if someone like Thabo Mbeki, former president of South Africa, goes to Khartoum to try and negotiate and develop peace that way than have al-Bashir here if we're a signatory on the Rome Statute?
Well, I think, you know, diplomatic initiatives can take place at a number of levels, but they've got to take place at the level of principle above all else. And the principle has got to be, how do we protect communities that are marginalized, that are being victimized, that are under threat of genocide and war crimes? That's got to be our fundamental base. How do we protect those people? And what efforts can we make, diplomatically and otherwise, to ensure that the most vulnerable in our societies are protected?
You're very firm on that, and you're very firm on your principles, and I'm sure that the court papers that you have with you today speak to that too. Lawson, let's say hypothetically there were an alternative body. Let's say there was a Pan-African version of the ICC. Would that make our departure more sort of palatable if there was somehow an institution that was kind of African-based, you know, centered at the AU, for instance, at Addis, and looked into questions of war crimes on the continent?
Certainly it would make a difference, because then we would have something else that we could fall back on. At the moment, our withdrawal from the ICC leaves us with no other recourse. And, you know, there are attempts to create an African court to deal with such matters, but it hasn't been progressing as well as many of us would have liked. It seems like it's still some way off becoming a reality and having jurisdiction over matters such as this. So, you know, the withdrawal from the Rome Statute is premature on a whole range of levels, fundamentally because it is the wrong thing to do, and secondly, because there's no alternative that is currently available.
So then we sit in a vacuum.
Means we sit in a vacuum, and it means that those who are the perpetrators of genocide and war crimes walk away with impunity.
Or walk into Sandton Convention Centre and walk out again onto a plane back to Khartoum. Lawson, it's been very, very helpful to have this conversation with you this morning, and I'm interested to see what's going to happen with the court case moving forward. We'll certainly keep tabs on it at News 24. And if there's anything that I've left out that you'd like to add in on this question, please go right ahead.
I think we've covered it. Thank you very much. Yeah.
Well, if you have any questions on this matter, or you'd like to share your opinion about the perceived bias of the ICC and its prosecutions to date, please do let us know on our Facebook page or on Twitter at News24, and we'll be happy to continue the conversation there. Lawson, thank you for your time this morning.
Thank you.
Thank you.